You're watching Morning at NTV.
Welcome back. We're glad you're still with us, and for those that are just joining us, welcome on board. You're watching Morning at NTV, and we are taking note of the performance of the justice sector in the year 2023. It's interesting, in the last 24 hours, a few words by the Fountain of Honor, the President of the Republic of Uganda, have put in a spot of bother the entire judiciary and how it conducts business. The letter itself is not unprecedented. The President has often come out to speak on matters that he feels aggrieved or concerned about. But the nature, the tone, and the choice of words for this particular letter is something that will no doubt flip the dynamics and how justice is dispensed. Must the law be the law, or should emotion and sometimes what somebody thinks on a personal basis be considered for a ruling? Well, I have lawyers with me who are going to help us understand these matters. Things are for landy people, you know. So, welcome, Mr. Isaac Otim.
Thank you.
Welcome to the program.
Thank you, it's a pleasure.
Welcome to Ronald Kiggundu.
Thank you so much.
Let me first ask you, what's your take on the President's missive to the Chief Justice?
I think the letter itself is misguided because we lawyers and the judiciary are a highly regulated institution. We follow certain values and principles, and the cornerstone of which is there should be principle of separation of powers, and this is something that the Constitution is very clear about.
That's right.
Whereas I personally think the President has a right to seek clarity or opinion of the head of institution. His letter doesn't seem to be one that seeks clarity, but the message or the language is very strong. Such strong language only says what his take is. It seems as though he's giving orders of what should be done.
Let's first get the the language you speak about, so that those of us who might not have read this letter understand the context within which we are speaking. To the Chief Justice, Alphonse Owin-Dolo, and Ministry of Justice and Constitutional Affairs, warrant of attachment and sale of immovable property on the Uganda Muslim Supreme Council. I have got a letter from His Eminence Mubaje, the Mufti of Uganda, regarding the quarrel about the sales of Muslim properties, etc. The letter is dated 29th November 2023. I had been hearing about those wrangles, but I had not focused my attention to them because I knew there are capable national institutions responsible for those issues, especially the judiciary you head. However, I was most surprised to read in Mufti Mubaje's letter that among the Muslim properties to be affected is the National Mosque at Old Kampala. Really? That is a word in the letter, by the way. It's not me. What sane person, let alone a judge, can make such orders? How can a mosque or church be attached for debts carelessly entered into by officials of that faith? If there is no law protecting institutions of worship, then common sense is there. I therefore request you to review this matter yourself and see how to restore sanity. His Eminence Mubaje alleges other examples of misconduct and collusion. You should study all those. What, however, provoked me was the audacity of attaching the National Mosque. The NRM freedom fighters and the government they head cannot be associated with Sikh logic. That is scathing, it is riveting, it is unprecedented. The attack on, first and foremost, the Chief Justice, his ability to lead the judiciary has been questioned. I do not know what his reaction will be, but we're expecting it a little bit later. Our team shall be covering that. Just finalize the submission and we shall have Ronald Kiggundu.
So as you can see, and as I've mentioned to you, the language of this letter is suggestive of some sort of order and criticism of what the judiciary is doing and the decisions are reached at. That is wrong, because the Constitution and the principles of justice, or how cases are decided, is very clear on when a party can be aggrieved and what you can do. For example, you might know that there was actually an appeal which was successful and there was a stay of execution. So a lot of things in this letter are wrong in the aspect of the judiciary, because one, there's a process of appeal. But also, for the president to suggest that the Chief Justice should handle this matter personally is to skip process, because there's an appellate court. And yes, exactly, and there's a hierarchy of courts. So when someone is aggrieved by the High Court, they can appeal to the Court of Appeal, and finally the Supreme Court. So and the Chief Justice sits at the Supreme Court, which is the highest appellate court. So there's a lot of skipping of procedure, but it's an attack on the judiciary, and it speaks to a lot on how our principle of separation of powers is handled, which I think is one thing.
I'm sure you agree entirely with Isaac Otim.
Exactly, and it's very absurd that the executive issues such a letter with such a language. One, this is an attack on the judiciary. It's an attack on the independence of the judiciary, because this shows that, I mean, with or without you, I can be able to say A, B, C, D. With or without you, I can tell you do A, B, C, D. And it is because it's like the executive is becoming an appellate court. Whoever is aggrieved, whoever feels court has been unjust to him or her in any way, will run to the president for an order and for a letter. It's not the first time, by the way. We saw that Nakasero issue. We've had many instances where the president will write directly to the Chief Justice, or it's really not a good precedent. And I think because these are two different entities, or two different arms of government, where the president can really first inquire, can really make a call, a courtesy call, to a head of the judiciary, what really happened. And there was already a stay. So what are you trying to insinuate then? When you try to you're trying to come out and to say that, okay, I think what the president is trying to say is, I'm the alpha and omega. Without me, I should give guidance in this, whether the judiciary has taken position or not. But even then, the judiciary should really be very, very careful at certain things. Because, I mean, where do you issue an order like which they issued? It was really very, because most of these are from public policy would still come in, the noise would still. You could look critically at it, and it was really not called for.
Let me ask.
Before
I know. Apologies for halting you in your tracks there, but let me just ask: when a ruling is being made, and a judge has listened to both sides of let me say, in broadcasting speak, of the stories, and when they are making their ruling, don't they base on facts of the law? That, for example, in this case, if somebody is found to be culpable to this extent, this is what happens, or this is the judgment or sentence that goes down on them. Isn't it how it happens? Or it's a case of the judiciary thinking or putting in place standards that, okay, by the time you're a judge, we believe that you are of sound mind and good intellect to make fair judgment. Is that how it works?
Of course, the judiciary is independent, and a judge or any judicial officer has the discretion to give their opinions within the context of law. And that's why we have a High Court, Court of Appeal, then a Supreme Court. So if there is any dissatisfaction about anything, we have a line, we have a hierarchy on how. If you're really aggrieved, you can appeal. Okay. So to me, I wouldn't really want to go because there would be an attack like on
you'll be
the judge or the person who I wouldn't want to go into that debate. But of course, there are also issues. My colleague must be knowing the issues that we have. Okay, I wouldn't really want to go into that line, but the issues.
Are there judgments that you also agree with as a practitioner of law that are either controversial or unfair? And in your mind, you're like, oh, I think this was a bit...
Most certainly, because we must recall, or we must know that judicial officers are human beings like us.
Okay.
Whereas they are, they make these opinions or judgments basing on the law. There could be differing of opinion, and the law envisages that.
Yeah.
The law, in the way it's made, envisages that there might be contention over judgments. There might be opinions that may not be conclusive of the matter, or you might find that the judge has made a judgment that does not really conclude the matter in its entirety. That is why we have appellate courts.
Okay.
That is why we have a hierarchy of courts. If the High Court has not satisfied your matter and your appeal has merit, then you can appeal to the Court of Appeal, and your matter will again be tried on the merit. If you're not satisfied with the Court of Appeal, then you can go to the Supreme Court, which is the final appellate court. The essence of this is that if there's something that has been missed out by the High Court, then you can urge it in the Court of Appeal, and the Court of Appeal could be able to determine the matter still within the context of the law. If the Court of Appeal has failed and you're still dissatisfied and your matter merits an appeal to the Supreme Court, then you can go to the Supreme Court, which will still give judgment basing on what you have presented. So it's highly unlikely that you're going to go through all these appeals and still fail to get
maybe in addition to
what you want.
Very quickly.
Like the question you were asking recently, I think were with and he has repeated it several times. Where I think that was the presidential petition, the electoral petition, where he said at the last hour, a certain judge had to be consulted to change his decision.
Consulted by who?
That one. But at the last hour, somebody they had to, and they had agreed because they had focused on, okay, this is our position, but they had to change.
You're triggering my mind as a journalist. Somebody was consulted to change their opinion.
He has said that even in his book, I think.
He has said it in his book. Yeah. All right. Kanyihaba is, of course, no holds barred when it comes to saying some of the things, and some of his books are pretty good to get into and understand exactly what's happening within the judiciary. Welcome to the program, George Musisi.
Pleasure to be here, Chris. Good morning to the viewers and good morning to my brothers.
We were discussing the president's letter, and before I transition into how the justice sector performed in 2023, what does this spell for the sector, the president's letter? Are you privy to what he said?
Yeah, sure, and I've listened to the views of my brothers. I entirely agree with them. But this shouldn't be seen as an isolated incident. It's actually a culmination of the president's different attacks, only that maybe this time it's so open. I think he has tried so much to undermine the judiciary. Possibly he doesn't believe anymore in the issue of separation of powers. By what he does, I remember many times he has been talking about the issues of bail. He has blasted judges before when they made rulings he didn't agree with. But the letter has so many different things. And for me, the content notwithstanding, because yes, there are public policy considerations of whether it was right to attach the most. For me, that is not an issue. Why it's not an issue? Every day we receive judgments in court which you don't agree with. The issue is if you disagree, there are inherent mechanisms, like they have rightly mentioned. But even in the form of the letter, first of all, he addresses the Chief Justice and the Minister of Justice, which is not right. Chief Justice heads a certain arm. Minister of Justice is directly under the President. So maybe the President, it gives us a hint of his mind that he doesn't see a difference between...
I was actually questioning the authenticity of this particular letter. The fact that it has not been debunked means...
No, certainly it's authentic because it has the receiving stamp from one of the people who are copied in the Speaker. Then you request the Chief Justice to entertain, to go personally and review this matter. One, the Chief Justice doesn't have jurisdiction to hear a matter which is before another court. The only time the Chief Justice has the jurisdiction is when the matter is before the Supreme Court. The Chief Justice cannot do administrative issues on a matter which is pending before another court. So the only thing you would have done is to wait for the processes to take on. But and then if the President doubts the sanity of a judicial officer who is at the level of the High Court, then because he disagrees with the decision, then what will litigants do? Even the Mufti, to invoke the president when you are a party to a matter which is, so that means that if I have access to the president, I can always circumvent and go to the president, who is the administrative chief justice, because the Mufti is a party, the UMC is a party before court. So then why do you beseech the president? So the letter is wrong. The president's considerations and notwithstanding what could have formed it. Possibly even many of us agree that it was wrong to attach a mosque. But if you take that course, then that means that even other DCs will stop respecting court orders. Interesting that you all agree the letter has rubbed the judiciary the wrong way. There is also an aspect, of course we shall not be discussing that here, that is very telling. How can a mosque or a church be attached for dates carelessly entered into by officials of that faith? That one is also something that should reveal the caliber of leaders, and that should, of course, offer a bit of fuel to some Muslim lawyers and actually, there's a lot of litigation going on in that matter. I don't think it even needs the president's intervention. There's a lot of litigation. The matters are able before court.
The path it is taking.
All right. So you are in the corridors of courts and how the law works within the country. How is this going to be handled? I just want your view. I don't know whether the Chief Justice will call a press conference. I don't know whether he will respond by writing back to the President. How is it going to be handled, most probably?
Well, I personally think the Chief Justice will not respond. If he would respond, it would surprise me. But if it were me, I wouldn't respond publicly because it is counterproductive. I mean, it doesn't really speak to what is right. So I would think the Chief Justice and the people who advise the President, Attorney General, probably should sit down with him and have a discussion about it. Like I told you, I find no problem with the President, the fountain of honor, the head of the executive, seeking clarity on matters of the judiciary.
It doesn't appear like
with a colleague, but this letter doesn't speak to seeking clarity. It speaks to giving orders. And I must also mention that there's a principle of law that once a matter is before courts, then we're not even allowed to discuss it. Mr.
And the President is very aware.
Yes, and the President is aware. I suppose he's aware, and he has mechanisms and people should be able to guide him. So I also think that the letter was rushed. Before reaching the Chief Justice, there should have been people he should have consulted. The Attorney General, for example, is employed to guide the executive and the President on such matters. The Minister of Justice and Constitutional Affairs is a very knowledgeable man, one who should be able to advise the President on matters of justice. And I think the letter was uncalled for, honestly. This could be something that could even be discussed over a meeting. So I personally think the Chief Justice will not respond publicly like we have seen.
Okay.
Yes.
Is it one that can call for a recall of members of Parliament from recess to discuss a matter of national interest?
Of course, it's not. It's a matter before courts. Ordinarily, Parliament shouldn't intervene. Of course, we've also seen since the incidents where Parliament has seemed to debate issues which are before courts, but they are prohibited, even under their laws, to discuss matters which is before court. Because this matter is being litigated. There was a decision of a registrar. The dissatisfied party appealed. A single justice of the commercial court upheld. But I think as per yesterday, the panel of judges put a stay onto that. And then there's another matter which was filed just this week before the land. So the matter is before courts. I don't think that if we are to agree the principle of separation of powers, the executive and legislature should leave it to courts, because court is the only arbiter of people in dispute.
When is a matter overtaken by events in the courts of law? Because this is an event.
I don't think this can be overtaken by events.
Okay.
Which event will be particular? Because those normally happen maybe with electoral petitions or with criminal cases, where you find that somebody has been in detention and you know, and probably judgment is delivered way like the Kasese issue and all that was that saga. But you in this particular instance, I don't think it can be overtaken by events. But the question you asked as well, the only issue the executive can do, like the President has always done, and which is most likely will be done, will be probably a bailout or pay off the money lender and let everything close. But away from that, I don't think his guidance will, because like he said, like my colleague said, the president doesn't have the chief justice doesn't have any powers or any jurisdiction to review any matter at this level. He doesn't.
Okay.
I think the PG doesn't. It only needs to go through that normal court process and will get judgment for that. But he can only probably maybe give the money, pay off the money lender, and the matter is concluded. But if you see closely, I think there is something behind all this, because it's not the first time like it is happening. Why borrow that money and then shoot and give a higher figure all through? And who benefits from this amount?
Okay.
You know, let's not look things at that angle only.
I would want to consider that as a considered opinion, of course, but within the context of this debate, let me leave it out.
It is a bit broad, because you cannot tell me you borrowed this much and then somebody wants over to not even to double, you know, thrice and
okay, that stands with the origins of the case where the property was encumbered and somebody was not told that it was encumbered, and then they sought a refund.
Actually, I was told. I've seen the agreement.
The interest began.
Yeah, Uganda Muslim Supreme Council undertook to clear the other encumbrances. I think in a period of 2 months, and then if you fail, you refund the money with a high interest. So of course, now those are issues before court which we wouldn't know. But there is some bit of and for me, I want to look at the conduct of the Uganda Muslim Supreme Council, because if you have been party to the agreement, which is a dispute, you are party to courts, then why do you go to the president and write and seek the president's intervention?
Public sympathy. And,
yes,
you know,
I think there is some bit of fraudulent conduct.
This is the carelessness the president says
yes.
later of some of the leaders of these faiths.
And I wouldn't really call it carelessness. Because
no, I'm quoting the president.
how would you even mortgage? How would you even, you know?
Okay. All right. Now, gentlemen, that of course has peppered the discussion, especially the beginning of it, but I wanted to understand, what do you make of the performance of the judiciary in 2023, the challenges? What are those aspects that you look back and say, well, I think we have done good. This challenge has been really heavy on the justice, law and order sector, but this is how it can be improved, and this is pretty much one of those aspects. Let me begin with George Musisi. 2023 justice sector performance.
I think the judiciary has increased its judicial officers, which has been one of possibly the biggest highlight. They have recruited much more judicial officers, magistrates and judges. They have opened up much more courts, which takes a step forward in terms of enabling people access justice. However, the issue of backlog is still something we're still grappling with. Backlog at the lower courts and also backlog at the highest court, the Supreme Court especially. If I start with the Supreme Court, realize that, of course, we know that they have lost 2 judges. Some we hear, like we heard from the Minister of Justice, are sickly. But we have constitutional petitions which are lying before the Supreme Court.
Another has been barred from retiring.
Another has been barred from retiring, and that
president.
And those public bickerings have also been part of the bad. But we have constitutional petitions lying before the Supreme Court, which the Supreme Court has not decided a constitutional petition in over 2 years. We are mindful that some of those petitions touch lives of so many people, because the constitutional petition you are saying, like for instance the one of trial of civilians in court martial, where the court grants a stay and then we don't get a decision. And then backlogs at the lower courts that, despite the increment in the number of judges, for instance, for so long we didn't see an increment in the number of state attorneys until recently when DPP recruited, because they complement each other. And then the work methods of some have not changed. Whereas some judicial officers have improved their work methods. Some people start courts at 8, but others have not improved, followed suit. So you realize that despite the increment in the number of judicial officers, it hasn't necessarily changed the work methods. Then, of course, judiciary also is bogged with so many interruptions. One of them right now, for the yesterday and today, most magistrates are not working because they're in a conference and registrars. Last week there was an East African conference. So you realize that those interruptions keep on piling up on the backlog. And then, of course, we cannot also dispute what we've been discussing. The issue of one of the challenges is independence of the judiciary. It's always under threat. It's always under threat from the executive, and now increasingly also sometimes under threat from internal threats. So the issue of independence of the judiciary, which we think is core to the performance, is also one of those that we're still grappling with as a country.
Okay. Isaac Otim, I know you agree with many aspects that George Musisi posits, but funding of the judiciary has been a long-standing challenge, and what my readings here say a budget enhancement is needed from 199 billion to an estimated 381 billion that is annual within the budget framework. Within the context of operations and service delivery, do you see something? Could we give the judiciary the benefit of the doubt and cut them some slack?
Definitely. You've had my brother tell you that the judiciary has, for example, recruited more.
Yeah.
Very many courts have been established to reduce the magisterial areas, for fear of being technical, to reduce the areas in which you can access justice. So with all those comes extra money.
Yeah.
I think what would demand of the judiciary is to be frugal. We want to know whether the money is being spent the right way. So I think, because remember, if you're employing more judicial officers, then they have to be paid.
That's right.
If you're creating more courts, then maybe structures have to be built, rent has to be paid. So we can't entirely say that the increase of the money is a bad idea. And I also think, if you putting into play the other issues that where's the economy at, and where are the issues of priority.
Yeah.
So I don't want to say that the money they're requesting for, or the budget increase they need, is not necessary. It is. Because even with the success in increasing judicial officers, we still need more, because we have cases coming up all the time. We still need more access to justice. We need more courts that are nearer to the people. So what I would ask the judiciary to do is to be frugal about the money they're receiving, because I've told you, most Ugandans like me will not so much care about how much money you're given, but how you use the money you're given. Yes, so I think it's not a bad idea that they request for more money. I think they just need to be frugal. They also need to address issues of priority. Yeah. What should be prioritized over the others, and where should the little money that you're given go as we plan for the rest. Of course, we are far from ideal or from perfect, but I think the steps and increase for money is a good idea if it's to be used the right way. Okay.
Ronald Kiggundu, your views, and perhaps throw some light on the progress of the plea bargaining framework and how it has perhaps eased the burden of congestion in the prisons across the country.
Personally, I must appreciate the judiciary and commend many judicial officers who have really done a great job. Many of them, we have very good judgments that you would really look at and say, okay, I think this judgment cannot even pass a test at the Court of Appeal. So we must really commend them. We must commend them for work done, and you know, personally on the issue of increasing the judges and all that. Or case backlog. Of course, it is really very pertinent that we should hear the cases in a timely manner, but we shouldn't really also rush them. We shouldn't rush them, you know. Because
you could reach conclusions like this.
Exactly, we shouldn't really rush them, and we have to finish. We have a deadline, as if you, because there are some which are really sensitive, and you really need to take time and peruse and be able to give a thorough judgment. We have many cases at Court of Appeal. Why do we have many cases at Court of Appeal? Because probably maybe High Court didn't do a good job. You can't have many cases at Court of Appeal if the judges at a High Court level are really thorough enough. Because I wouldn't try to mention many of the judgments or judges who have delivered really perfect judgments, but the backlog at Court of Appeal and the pressure and all that, sometimes I think it is not called for, because it all originates from down, you know, from the lower courts. They should be able to do a very good job so that we decrease on the number of cases at Court of Appeal and Supreme Court. On plea bargaining, I think I've normally seen I think even the DPP and the judiciary trying to give more knowledge and educate people about plea bargaining, which is really a good one because it reduces the litigation. Many of these cases wouldn't really go in court, and you know the system begins with the whole justice system begins at police. And that's where I think we should always begin from, because most of these cases go to court. They shouldn't really go there. You find that it's something that would really be done even at police level. But you find that a matter is not really investigated because there is either politics or it has been rushed, it has gone to court, there is no evidence, then they'll keep doing putting up adjournments all the time. It is not really called for. So plea bargaining is a good one, but because it reduces the case backlog in courts and the litigation, but it also should be done in a way that people are free to, they do it willingly, because I've seen circumstances as if the DPP normally advocates to it too much, and as if it should be done, and if it is not done, you have no way out. You know, people should be left free.
Actually, just a short one, Chris, on the issue of what Ronald is saying. Many of the people who go for plea bargaining, it's because of the problems of the judicial system.
Exactly.
That those people who are on pre-trial detention, who are waiting for their trials before the High Court, especially on capital offences, you spend at an average of 5 to 6 years before facing a trial. So if there is a plea bargaining session, instead of waiting for the next 6 years,
are tired.
Yes, they would rather go, even if they're not guilty. Sometimes they plead guilty for purposes of circumventing. Sometimes it's a failure of the system that people plead guilty even for purposes of avoiding a longer jail sentence.
Isaac Otim, the spectre of corruption in the judiciary. We recently had a case of, was she a magistrate or chief magistrate? But she should have been a chief magistrate.
Chief magistrate.
She was remanded on account of alleged bribe. Being a journalist, I'm still using alleged.
Yeah, she's still a suspect.
2.5 million Ghana shillings. You know, there was also a prosecutor who was involved therein. The embarrassment was there, but to the country and to the court of public opinion, it was something people were like, yeah, there you are, we know it. You know, I'm not sure whether you share the same sentiment with the public or you are more knowledgeable of how corruption works within the judiciary. If you can, paint us a picture.
Well, I think it is undeniable, sadly it's undeniable that there are a few cases of corruption. But I would also, I am careful not to taint the whole judiciary to be corrupt.
Of course.
But also corruption is three-dimensional. Sometimes we enable it, you know. It's a society rot. You can't exactly peg it on the judiciary because, again, with issues of backlog, and you want to get your order very fast and you want your file to move, that's corruption. If you give 20,000 or 100,000 to the clerk to move your file, that's the beginning of corruption. So they are isolated issues of judicial officers, like the alleged the offense we just spoken about of the chief magistrate. But I don't want to take the whole judiciary. I think we need to come together. It's not an issue of the judiciary. It's an issue of us, the officers of court. It's an issue of the public, because there are instances where you'll find someone saying, let's give something for our file to move. But like I said, we need to judge the judiciary on standards. And our legal framework, I told you the judiciary and our profession are very highly regulated and with standards.
That's right.
So if we all came together, because the judiciary itself cannot, the standards are not just for the judiciary, the standards are for us who use the court, the legal officers. The standards are also for the litigants. So we must hold the judicial officers to a high standard, but we must also enable the high standards. It's something we must do. So it's undeniable, but it's not an issue that is tainting the whole judiciary. We need to work against it, and I'm glad that the judiciary is also handling these matters. We are aware that this matter is being handled, and the alleged offense is being investigated, and I believe we shall soon have a ruling or some sort of outcome from that issue.
What do you have to say about corruption?
Well, corruption is part of our society.
He has said that it's three-dimensional, but let me keep to the dimension of the judiciary. You have, no, when I say you, I'm involving you're lawyers, practitioners, you're not judges and judicial officers. But how can it be dealt with? Because it's there, but how?
Yes, and I'm trying to build a context that you cannot look at the judiciary in isolation of everyone around them. Okay. So we have corruption is part of us in Uganda.
Maybe, I'm sorry, let me halt you in your tracks there. I have to go for a short break, and then when I return, we shall go first with you as we do the wrap-up for this particular discussion. Do stay with us. You are watching Morning at NTV. We are taking note of the performance of the judiciary in the year 2023 as we inch closer to Christmas, of course. Do stay with us. We'll be right back and continue the conversation.
Back to you in the studios.
And they have
Stand by. All right, interesting. The debate here in the studio is, well, very, very lively. The matters that we are handling today are quite, some could say, emotive. Let me return to my guests, George Musisi, a lawyer, Isaac Otim, and Ronald Kiggundu, as we discuss the justice sector and its performance in 2023. I was speaking, or rather, on the lawyer, George Musisi, you had the floor.
Yes, on the issue of corruption, I was just making the point that
quickly dwell on corruption, but I also want to understand something about a certain plea that was made, especially to judges, magistrates, that there are some cases that do not need certain sentences. And it's something that should be able to help the prisons reduce on what? Congestion. If a boy who is hawking eggs on the streets of Kampala finds himself at KCCA court and then he's remanded for 2 weeks, this is a boy selling eggs, trying to ensure that either fees comes in or he's also trying to provide for his siblings. The judge at that point, or the magistrate, should be able to look into that matter. There must be lesser or effective sentences that can be worked out quickly, and then that is dealt with. Please.
Yes, very quickly. Yes, I was saying that corruption, we have to look at in a bigger context because judiciary is part of society.
That's right.
So if there are no checks or if there are no risks that make corruption hard in society, because Africans are not more corrupt than whites. Yeah. The difference is there are more stringent risks that if you are caught, yes, in the West. So the problem here is that there is impunity, there is a lack of respect for the rule of law, there is godfatherism, that they know that if a person has got the position as because of corruption, then there is no way that person will not be corrupt in the course of their practice. So for me, I think we just have to look at judiciary with a bigger context. It's not more corrupt than other institutions. Even in parliament, even in the executive, there's corruption. So we just have to look at it as a cancer in society and deal with it and make it hard, make it risky. Okay. The issue of sentences, of course, the Constitution provides that judicial power is derived from the people and should be exercised in accordance with their aspirations. And that is something maybe that many judicial officers don't fully appreciate. And possibly even the data we're talking about, if the judicial officer was alive to that, maybe wouldn't have listed the president. Yeah, they wouldn't have listed the Moscas. Yeah. Because you have to look at public policy considerations. And I think it's an ongoing process. It's an ongoing process. That why do you keep on remanding? And you're talking about the Hawk at KCCA court remanding a person. Yeah. Even in other smaller courts, you find someone, DPP keeps on saying we're investigating. You keep on reminding people. Many times these colleagues of mine will know that you go to a court and then the judicial officer says, no, the state is not there, so we are all remanding. Or the trial magistrate is not there, so I'm not entertaining bail. As if, so all those are some of the smaller things which clog prisons, but as a result of practice. That's right. Because I always ask, if I'm sitting in for Ronald, I'm also a magistrate. I have every right to entertain a bail application. That is right. Why should I remand someone because the state is sick? The state is a lawyer like me. Supposing a private lawyer wouldn't come to court, would they say that let's not proceed because... So for me, those are some of the things that judiciary just needs to appreciate and know that they are sitting there as a result of doing justice in accordance to people's aspirations. So it's a broader thing that they just need to appreciate. And some of those small practices, of course there are some good ones. There are really some judicial officers who go out of their way to enhance. One of the one that has been overwhelmingly good, but not over in the media, is Justice Mutonyi in the criminal court. She's really coming out with some very good judgments about police and how it handles investigations. They don't receive a lot of prominence, but she's really one who deserves all the kudos this year.
All right, Isaac Otim, very quickly, the cost of justice to the layman is exorbitant. Lawyers are unaffordable. The bills are too much. I know a lawyer who bills a phone call. You call
Even Isaac does.
Why? How can't you make these services affordable to some of us?
That's a bit of a complicated question, but this is what I'll say about it. Access to justice shouldn't be expensive. It shouldn't be exorbitant.
That's right.
And that is why the law has in its means created some ways in which the indigent or the people who can't afford the flashy legal services,
pro bono.
Yes, if you can't afford my colleague's services, probably who's billing per phone call, as you say, then there's legal aid. Even our society, our society provides legal aid, and there are very many of such institutions. So to the lay person out there who can't afford the expensive legal services, there are people who are doing a great job. The Law Council, for example, the Law Society has the pro bono program, and has also the legal aid program. We have programs like LDC, for example, the institution that we all go through, has a legal program, and there are so many of these. So I personally believe there's a place for everyone. You may not, and that's just how society is, you may not be able to afford the services, for example, a proprietor or a rich tycoon in town can.
That's right.
But there is always a way you can get justice. So I encourage the public to look out for the legal aid programs. There's one at Law Development Center, there's one at the Uganda Law Society. There's the Muslim, the Muslim fraternity has a legal service.
Have these been diversified across the country?
Yes.
Especially for those in
Uganda Law Society, for example, operates law clinics across the country. The Law Development Center has now decentralized. So everywhere where you find a Law Development Center, you'll find a legal clinic as well with capable legal officers. So let us not hide away from justice simply because we can't afford the expensive law firms. These services also exist, and by the law so mandates us who I decide to provide free services once in a while.
All right, finally, Ronald Kiggundu, a human rights perspective, the loss of confidence in the courts of law to deliver for the people who are powerless, for those that see themselves as marginalized, is a growing concern. I don't know whether there are specific attempts to reverse that spectre that you know of, but your last words within the perspective of human rights.
One, I think, like I said earlier, it all begins at police. You cannot tell me that you have arrested somebody, there is no file developed yet. We have the 48 hours rule. You will find that you'll have to rush now the file. It goes to state with only probably one statement or the first statement from the IO. Nothing at all, just only those two plain statements. Then you go to court, apply for bail. Of course, that's a different issue altogether now. Then they will tell you the matter is not yet, we're still under further investigations, and probably somebody will interfere with the investigations. You shouldn't be released on bail. There is a judgment which I really liked most by Justice Kiggundu, who I gave a lot of respect and because most of these judgments are really so nice. You'll find that, I think that was the case of Nicholas Opio versus, I don't know, but it's very well, where he said that most of these investigations or further investigations shouldn't be a battle to grant bail.
To grant bail.
Yes. Why do you want to? Why do you prosecute a case without investigating? Why would you arrest somebody without a file?
If you don't have
evidence,
why?
Yeah. Don't arrest then. wait, develop a file very well, have evidence on record statements, have all the exhibits, then arrest. Then it will probably take you 1 or 2 days to go to court. Those are the issues that bring in human rights issues, that people will start complaining, you know. But really, it is because of that system. Because if you do it perfectly, you won't have any of those issues happen. Yes.
All right.
It's not necessary for you to do an arrest. You have not investigated. Then you come to court. Then you start denying still bail because you think somebody will interfere with the witnesses. It's not really called for.
All right, gentlemen, I think that's a task that we shall leave to all stakeholders within the justice, law and order sector to ensure that when 2024 begins to roll out, every one of us can be happy and have the confidence that justice will be dispensed, timely matter, so that at the end of it all, no one sees themselves as unfairly treated. Ronald Kiggundu, Isaac Otim, and George Musisi, many thanks for the perspective. Your submissions were superb.
Thank you. Pleasure.
And that's it for the Tech Note, a look at how the justice sector performed 2023, and of course also perspective on the president's missive. That is something we are following up big in the newsroom, and later in our bulletins we shall be dissecting what it means for the average Ugandan. We shall be now talking the arts, that is of course bursting with creativity and potential, especially in the media and the arts sector. Do stay with us.